This dude, what's your name, sir?
I'm not going to address it, sir.
All right, Mr. Davis,
He, in June, he was, doing, law that don't pertain to me. He kept on quoting it. Then the next, in July, he did the same thing. Saying laws that don't pertain to me. That's wrong. And, another thing.
Attorney is going to potentially appeal this, so
Okay, let me
we'll get
say,
some clarity on this.
okay, August 9th, two deputies from two COs came to my cell, asked for the extra mattress. I gave, told them to take it. You know what I'm saying? I think they were sent by them to beat me up. So they brutally beat me up, they attacked me and assaulted me. And it was wrong. I told them I had cancer and I'm on blood thinners. You know what I'm saying? So I asked them what's their name. The sergeants ran them out the door. So I talked to my California lawyer. He said they usually send inmates or young deputies to do this type of stuff, just so I would y'all can have something to say that I attacked them or fought them back or nothing. So I just stood there because I got cancer and I'm on blood thinners. So I just stood there and let them assault me and beat me up. Then I tried to get the press here to come see me, my family. They blocked my visits, everything. This is wrong. This is law. This is wrong. What?
You've made very serious allegations regarding police brutality and the DA's orchestrating some sort of attack on you.
My lawyers.
I wasn't aware of any of this.
Oh, August 9th,
saying
he did
that
it.
so they can say that you attacked them. It was never brought to my attention, so there's nothing to connect that allegation. Ultimately, I think you need to be aware of the things that you're saying.
They attacked me and assaulted me. The whole place seen it.
All
And
right.
they got the bubble little camera there.
If
And
there's
I asked them for their name. They ran them out the door. And that's wrong. I'm on blood thinners. And that's the first thing on the thing. Say, do not have no altercation. Because you know, a bloody nose and you can die. You know what I'm saying? And that's wrong. I got cancer. I kept on telling them deputies, what are you doing? What's wrong with you guys? What is wrong with you guys? I'm old enough to be a dad, man. You know, have some compassion. What is wrong with y'all? And they took $300-some worth of food out of my cell and everything. This is wrong.
All right. We've had hearings regarding things that have happened at the jail. If you have something that you want Mr. Arnold to file, he can file it. And if there's an issue about connecting those two things that you have alleged, we can absolutely have a hearing on that if Mr. Arnold brings it to my attention.
I appreciate it, and I wish there's something they'd be disciplined, fired. Something needs to happen to
Give me
them.
more
They
information,
wrong.
'cause at this point you don't have really much connecting this, okay?
No, I got the nurses. I got the nurses thing. I filed with the
Submit
nurse. I submitted it and everything.
Submit it to me, let Mr. Arnold know so he can submit it to me and I can review it, okay?
After. I think these motions are extremely relevant to this case. If not dismissal, but potential for evidentiary objections that need to be lodged in this case. So we're asking for continuance and believe good cause exists.
State what's your position.
No objection.
You've been made aware of this, Mr. Davis?
Yes.
And you understand that your attorney's asking for more time to get these items done?
Yeah.
Okay. I'll find good cause to continue the trial. When did you want to reset it, Mr. Arnold?
I would say at the beginning of the new year, towards March or April.
April's better.
April's kind of taken up by a 2015 case that I can't move, which will take about
I have a
4
capital
weeks.
case April 7th, so
What
that'll
about
take 6 weeks.
March 17th? Does that work for anyone? Everyone?
I can make it work.
Yes, Your Honor.
Okay, we'll reset it to March 17th, 9 a.m. with a calendar call March 11th. The next thing I wanted to address was Mr. Arnold's motion to reconsider. All right, so I just want to get everybody up to speed on what has been happening in this matter, and then I'll hear from you, Mr. Arnold, regarding what needs to be done next. All right, so last time we were present on the motion to reconsider. I took it under advisement. Then after additional review of ultimately the transcript of the things that Mr. Arnold had represented, I issued a minute order requesting additional information from AG Entertainment that the money they paid Cash Jones was for previous work as Mr. Arnold represented, as opposed to some other purpose. On 7/29, Mr. Arnold provided an invoice from Mr. Jones with no acknowledgement from AG Entertainment that they received it or that the items on it were paid for those items. I think that was shared with both parties. Then the court asked for something from AG Entertainment, specifically that the $112,500 was paid for work done by Mr. Jones previously. Like I said, that had been represented by Mr. Arnold. And then I received the following letter from an Adam W. at AG on AG letterhead on 7/31. It stated, we received the invoice dated June 1st from 100 Entertainment Incorporated. On June 11th, 2024, we sent a wire of $112,500 to 100 Entertainment Incorporated for this invoice, admin, Adam W., and then there was a number and an email. So I had my law clerk call and email numerous times, left several voicemails. We never received a response from Mr. W. Then on 8/2, I received another letter from a Shonya Pittman Roach. We did research her and did find that she had a connection to AG Entertainment, but her name was ultimately misspelled and the address on the letter returned to a doctor's office. So the letter ultimately said the exact thing, verbatim, as what we had received from Mr. W. Which was, we received an invoice dated June 1st, 2024 from 100 Entertainment Incorporated. On June 11th, 2024, we sent a wire of $112,500 to 100 Entertainment Incorporated for this invoice. Regards, Shonya Pittman Roach, Director of Operations. The law clerk again attempted to reach her via phone number numerous times, left voicemails. There was no email to reach out for, but ultimately we did not get a call back. Mr. Arnold then reached out to our office approximately August 13th and asked us what was going on. Why weren't we contacting these people? We informed him we had been trying, we hadn't gotten any response. But at that point, upon Mr. Arnold's urging, we recalled the two numbers that we had. Ultimately, my law clerk was able to talk to Ms. Roach. She did tell us that there's no Adam W. who works there. She doesn't know who sent that first letter. We asked her why this was identical language that was included in both letters. She indicated that Smiley Bail Bonds reached out to her and told her what to write. She forwarded us an email from them indicating that 100 Entertainment received a wire from AG Touring in that amount on June 11, 2024. We just need letterhead or an email from you, AG Touring, representative or accountant for this company acknowledging the transaction. No other details need to be explained, as AG Touring has no involvement with this transaction. The purpose of this verification is solely for the source of funds. Below is a statement we already provided the court. Please use the same language as nothing further needs to be explained. Appreciate your help and understanding. And then it contained the identical language that we received from Mr. W. and that we received from ultimately Ms. Roach. And so at this point, ultimately, I still have a lot of concerns about what has been sent to me, and that's why I haven't issued any further orders. I had hoped to address this last week, but ultimately Mr. Arnold wasn't available, so we set it to today's date, and so that's kind of what I hope to get to the bottom of today. Concerning to the court is that I don't know who Adam W. is and why other people in AG Entertainment are indicating that they don't know who this person is, if he did use, in fact, that AG letterhead, and ultimately why there seems to be sort of this obfuscation of why AG is giving this money and the direction ultimately not to give me any additional information. So, Mr. Arnold, that's sort of what I wanted to address today and get to the bottom of, to see if ultimately these are funds from a legitimate source, and we can proceed with this release. So, Mr. Arnold, what did you want to respond?
Yes, Your Honor. I forward to the court a letter from Smiley Bail Bonds. They advised me that, again, similar to what Ms. Roach told you, that they were the ones that put together the letter. It's my understanding that there's no Adam W., that what was supposed to be admin email was misspelled or autocorrect was used, and it kicked out Adam as opposed to admin. The other thing that I'm aware of is that Ms. Roach like you said, I believe it contacted you and told you she was the one that personally did the wire. However, they do not want to reveal the different concerts and individuals involved simply because of repercussions that they may have in doing further business with those individuals. Obviously, no one wants to be directly related to providing money to bail out Mr. Davis. But again, these were monies that were given in payment to Cash Jones, and Cash Jones utilized the money how he deemed fit. Lastly, Your Honor, I'm also aware that Mr. Jones, again, because of his involvement in testifying at the last court, 2 court proceedings ago, that he's been receiving death threats. So
Mr. Arnold, your cell phone cut out?
Now it's muted, Your Honor.
Oh, you muted yourself, sir.
sorry about that, Your Honor. But again, Smiley Face bail bonds is on line and can give further explanation in regards to the letters. That's all the information that I have before.
So the last thing I had said, that you had said before you cut out, was that Cash Jones has received death threats. What ultimately was the relevance of that? Because I think I might have lost the end of your argument on that.
Oh, yes, Your Honor, that Cash Jones no longer, wants to give testimony or, show, the public that he's involved in this any further than he has. So, and then I went into Smiley Face Bail Bonds owner is able to discuss the actual letter received from AT Entertainment.
Okay. State.
Your Honor, first, as an officer of the court, I would advise the Smiley Court bail bondman not to give a statement, because after seeing his letter, it appears that he submitted a false document to this court, which is a felony, which the state takes very seriously. In the letter that he just provided, he said, I cut and paste the body of this thing and then sent it to you for the purposes of meeting whatever this court's requirement is. And uttering that instrument to this court in that manner is a felony, and I think the state takes that very seriously, especially from a bail bondman. So as an officer of the court, I think it may be advised that that will not go uninvestigated, that statement, because the state believes he admitted to committing a felony in that statement, number one. Number two, I'm not surprised that Cash Jones doesn't want to come here and testify, given how his testimony came off last time. He absolutely lied to this court with regard to his representation as to why he was providing the funds and where the funds were coming from. It was demonstrably false testimony. And so, Your Honor, I am not surprised that when this court tries to look under the rock from where this money is coming from, this court gets more fraud. And when this court pursues, well, where does this money come from? This court gets more fraud. And then when Mr. Arnold has the bail bondsman try to explain what he did in altering the document that was submitted to this court gets more fraud. This court has already ruled that or at least has ruled that this court is willing to consider the source of funds. But it has to be a legitimate source of funds. And when we are obfuscating the source of the funds, it's a clear violation of this court's order. It is at its most fundamental, it should be fairly easy to say this is where the money comes from. Additionally, if this court were to consider this, to want to keep on pulling up the rocks to see where all this fraud is coming from, it defeats the purpose of the source hearing to have Mr. Jones say, yeah, I got this money from this person and that's where I'm spending it, without us getting to talk to and having sworn testimony from this person from which the source emanates from. So I think at the very least, the bail bondsman is not the correct source for the source of funds. It is the person from whom the invoice is coming from, which is the correct person that we would need under oath to testify about the validity of the source of funds. So then that's the state's position with regard to that. I would, I guess, inquire of the court. There was also a counter motion to reconsider, and I don't know if this court has made a ruling or not on that.
Address that as well.
Okay, so the court is just, the state has a, I think that's also an issue that's pending as well.
All right. Mr. Arnold, any final word?
Yes, Your Honor. In regards to uncovering the source, Your Honor spoke to AG Entertainment. AG Entertainment is a legitimate business. There's no discussion in regards to that. AG Entertainment had a legitimate business relationship with Cash Jones and WAC Entertainment, WAC 100. They sent those monies by wire, which she explained to you, and Cash Jones used those monies for his bail. There's nothing in the record that suggests that these two businesses are illegitimate, that these monies came from drug proceeds, gang-related activities, or anything of a nefarious nature. The only concern that the court had was in regards to whether Mr. Davis was going to make a profit off of this money. However, as discussed in my motion to reconsider, that's no longer or should not be the court's concern, simply because Mr. Davis has not been convicted. So back to what is the standard of a Nebia hearing? The standard is, do the funds from a legitimate source? And nothing in the record and nothing the state has provided can dispute that these funds have come from two legitimate business sources.
All right. I don't find there's enough to reconsider my initial finding that the defense hasn't made a prima facie case about that this was from a legitimate source and the reason for it. Ultimately, I don't want to accuse anyone of anything, but I have a sense that things are trying to be covered up in ultimately what's being presented to me. Additionally, or conversely, I also don't find that there's enough new information being presented to me to reconsider the proof evident presumption rate findings. So the counter motion is denied. The motion to reconsider is denied. The counter motion is also denied. Yes, sir.
This dude, what's your name, sir?
I'm not going to address you, sir.
All right, Mr. Davis.
He, in June,
Sure.
he was, doing, law that don't pertain to me. He kept on quoting it. Then the next, in July, he did the same thing. Saying laws that don't pertain to me. That's wrong. And, on another thing.
Attorney is going to potentially appeal this. So
Okay, let me
we'll get
say-
some clarity on this.
Okay, August 9th, two deputies from two COs came to my cell, asked for the extra mattress. I gave, told them to take it. You know what I'm saying? I think they were sent by them to beat me up. And they brutally beat me up, they attacked me and assaulted me. And it was wrong. I told them I had cancer and I'm on blood thinners. You know what I'm saying? So I asked them what's their name. The sergeants ran them out the door. So I talked to my California lawyer. He said they usually send inmates or young deputies to do this type of stuff. Just so I would, y'all can have something to say that I attacked them or fought them back or nothing. So I just stood there because I got cancer and I'm on blood thinners. So I just stood there and let them assault me and beat me up. Then I tried to get the press here to come see me, my family. They blocked my visits, everything. This is wrong. This is wrong. This is wrong. What?
You've made very serious allegations regarding police brutality and the DA's orchestrating some sort of attack on you.
My lawyers.
I wasn't aware of any of this.
August
So you're
9th,
saying
he
that
did it.
it's,
His
so
name,
they can say that you attacked them. It was never brought to my attention, so there's nothing to connect that allegation. Ultimately, I think you need to be aware of the things that you're saying.
They
you
attacked me and assaulted me. The whole place seen it.
All
And
right.
they got the bubble little camera there.
If there's
I asked them for their name. They ran them out the door. And that's wrong. I'm on blood thinners. And that's the first thing on the thing. Say, do not have no altercation. Because you know, a bloody nose and you can die. You know what I'm saying? And that's wrong. I got cancer. I kept on telling them deputies, what are you doing? What's wrong with you guys? What is wrong with you guys? I'm old enough to be a dad, man. You know, have some compassion. What is wrong with y'all? And they took $300 some worth of food out of my cell and everything. It's wrong.
All right. We've had hearings regarding things that have happened at the jail. If you have something that you want Mr. Arnold to file, he can file it. And if there's an issue about connecting those two things that you have alleged, we can absolutely have a hearing on that if Mr. Arnold brings it to my attention.
I appreciate it, and I wish they'd be disciplined, fired. Something needs to happen,
Give me
and
more
they
information,
wrong.
'cause at this point, you don't have really much connecting this, okay?
No, I got the nurses. I got the nurses thing. I filed with the
Submit
nurse. I submitted it and everything.
Submit it to me, let Mr. Arnold know so he can submit it to me and I can review it, okay?
Okay.
All right, I think we have to get you back pretty quickly. It's because at 10:30 you need to go somewhere. So we are now done with Mr. Davis so that he can be taken back for that appointment.
Thank you, Your Honor.
He's up. I think Miss O'Neill, sorry, Miss McNeil is here on the solid matter. Yes. Are you also here for Miss Ellen or is she coming independent?
I am not here for her, but I can be if I need to.
You don't have to. Well, unless you know that you're here, I just was